places, we'll get started. All right, before we continue, we have just wanted to let the board members know that we received a letter from Lisa Brown and Kevin Johnson. And Michelle, can you explain a little bit more what the letter is?
Yes, so this letter is addressed to the board members, and it's regarding sampling and testing recommendations. So when you have a chance, please read over it. But essentially, they are asking for a wet standard when it comes to testing for THC, as well as recommending that the sampling collection would have both options available to the grower, testing lab, and or the agricultural commissioner. So just when you get a chance, please read it. They also attached Oregon's testing protocols to their letter, so that's it. Oh, it's in your packet.
All right, is Tom still here from the lab? No, Don. Quick question. Somebody from another lab or some other people gave us a recommendation about testing, and they recommended that we have a wet sample. And I was wondering if you could maybe tell us the difference between testing between a wet sample and a dry sample. Yeah.
Samples can have a lot of moisture in them, right? And it can be, so now you're looking for a very small value of analyte in the presence of this added water. So that makes the test less precise, a little more difficult. And as stated in the letter, the cannabis that we test is usually not wet. Although we do test wet cannabis, we dry it first. And we do have the capability of test for moisture content, and that's what you need because the 0.3% is on a basis of a dry weight, right? So you'd have to know the moisture accurately enough, and then I think I'm not familiar with this fact that it has to be tested at no more than 13% moisture content, but I imagine that's because with higher moisture contents, the accuracy of getting down to 0.3% of the total dry weight is just that much more difficult, but I don't know for sure.
All right, because it seems like this recommendation is they're saying that, from what I can tell, it seems like they're saying it's more accurate if it's wet. Are you saying the opposite of that?
Yeah, well, it's not, they're not saying that, I think it's easier to deal with because you don't have to dry it, right? So you could have a sample come off the plants, shipped to the lab or whatever and run immediately as opposed to waiting to dry it somehow, right? Mm-hmm. But it would not be more accurate to test it wet.
So you would, even if you got it wet, you would dry it anyway before you tested it?
Yes, we would partially dry it. We use a desiccator, so just something like calcium chloride or something in a sealed container, but it takes overnight. But overnight it gets down to pretty close. And then we would do the final analysis where we would test both the moisture content and the THC content so that we can do the calculation. But we always have to do that, right? Because no sample we get is perfectly dry. So we always have to measure moisture content and then the THC as a fraction of dry weight, I think, is the way the regs are usually.
All right, actually, it looks like they're recommending that we offer both. So their recommendation here is that we offer both wet and dry for the farmers, which might be easier or something like that. I mean, if they're just going to chop off a sample, they would not have to dry it themselves.
Yeah, and there the issue is really just maintaining the integrity so it doesn't mold before you get around to testing it and stuff. So.
Okay. All right. Thank you. And then, Josh, you wanted to mention something about.
Sure, well, the Word doc that we just added should be the most recent thing.
It should be labeled the sampling testing guidelines.
One over. Try that one. There we go. Okay. I cannot read that very well from here. So what we did was just, since there was a lot of discussion on the sampling and testing guidelines that had already been discussed by the board, we went in and cleaned up the guidelines that had been handed out at the July, or that had been previously discussed at the July meeting, and actually were discussed before that as well. But this is what CDFA had put together for the July meeting as a summary of what Richard and Allison had worked on. And so we just wanted to really quickly run through that. Just as far as what the main contents are, and I obviously won't read all of it, but just run through the main components of what was proposed. So they recommended.
Josh?
Yes.
It's in our minutes, too.
Correct.
If you want to look at it.
Correct, and so we cleaned up that version, but it is in the minutes of the last meeting as well. So it includes the notification of harvest date. Actually, if we can zoom in a little bit. There we go. That's better. I can almost read that. So we have a notification of harvest date because sampling needs to occur no more than 30 days prior to harvesting. At that meeting, that was simply a recommendation from Allison and Richard. However, that is now in pending law that will take effect January 1st, thanks to SB 1409. So the sampling timeframe, sampling shall occur no more than 30 days prior to harvest. There's a site verification where they require that the sampler needs to verify the collection site and make sure that it corresponds with the information that was submitted on the application. Collection of samples, so the recommendation from Allison and Richard was for actually they didn't go into whether it was randomly or in what manner the plants to be sampled would be determined. However, that it would be sampled by the sampler that we're discussing here today, trying to figure out who that is. Sample volume, so they recommended that a separate composite sample be taken for each plant variety, that a separate composite sample be taken for the same plant variety grown either indoors or outdoors. So if you have the same variety growing indoors and outdoors, you would take one composite sample for each of those two grows. A separate composite sample should be taken for each non-contiguous field. So if there's a break in the field, even if it's the same variety, that would require an additional sample. The composite sample would be made up of at least 5 samples from different plants of the same variety in the same field. Samples would include the plant's stems, stalks, flowers, leaves, seeds, and buds, all plants intended to be included in the extraction process. The samples should not be taken from male plants, and that the sampler should avoid collecting samples near field edges. And also that any abnormal plants would be sampled individually as well. And then they had instructions for sample handling, including maintaining the sample in a breathable bag, basically a brown paper bag, and kept in a cool storage so that way it's not conducive to mold, and delivered. And the delivery time frame they recommended was same day to the lab. And then as a follow-up to that, there was some discussion of a confirmation of harvest to make sure that harvest did in fact occur within the 30-day time frame. And they were working on some kind of a form for that, but that would be kind of outside of this discussion. And then regarding testing, so if we go to the second page, the recommendation for sample preparation, each composite sample would be dried and milled to a homogeneous powder-like consistency. And for dried, it would be a moisture content of no more than 13%. And for powder-like consistency, the recommended use of a 1 millimeter screen. We weren't sure exactly how to word that, so that still needs to get worked on a little bit there. No plant parts should be removed during the sample preparation process. They didn't really have any recommendations regarding sample storage. However, testing, each composite sample would be tested separately using the approved testing method. And the testing method that they recommended was gas chromatography with a flame ionization detector, as is the standard in most states in the U.S. For sample retention, they recommended that samples with less than 0.3% THC be retained by the laboratory for at least 30 days, and samples with THC levels of more than 0.3% but less than 1% would be retained for at least 60 days. Again, I'm not sure how much discretion the department would have in making these types of recommendations, but that's something we would need to discuss. They did not have any recommendations on sample disposal. However, for notification of test results, it was recommended that the registrant should be notified of test results within 10 days of sampling, and I believe we had somewhere in there about sending those results both to the registrant as well as to the county agricultural commissioner. And then they did have some recommendations regarding retesting of harvested material, which, as we've discussed, conflicts with the both existing and proposed law, or pending law. And then a note from CFA, so in addition to those, we did notice that there are some additional things that may need to be in the lab SOPs that may or may not need to be addressed by the board or through regulation, including things like cross-contamination, identification of samples, the size of the sample itself, as in how much material, sample storage at the lab, sample disposal at the lab, et cetera. So some of those things that we did not get into, and whether or not they would be really necessary for working with an ISO-accredited lab, I don't know, but those were other things that we had brought up. And then, and then they also provided, they actually did provide some answers to some of those questions. What Richard and Allison did was look at the current SOP requirements for cannabis testing laboratories and revise them for the purposes of hemp, including things like video recording the sampling. Is there anything else that we needed to point out in there? Yeah, which may or may not be necessary and weren't in this final proposal that we put together.
All right, now we get back to the subject that we left off at which was the sampling responsibilities and procedures. The main question is the chain of custody. And it looks like Richard made a recommendation that it can be handled by the county, but then the county could, if they didn't have enough manpower or they didn't have enough people to do it, could designate one of the registered labs or CDFA-approved labs to handle it. So I think the difference here from what we had said before is rather having the farmer choose the lab, it would be the CDFA and possibly choose a private lab. Is that correct?
No, the farmer gets to choose the lab, but you're right. It's the ag commissioner gets to take the sample. If the ag commissioner decides not to take the sample, then the lab would take the sample, but the farmer would pick the lab, and a farm representative would be there when the sample was taken by whoever.
Okay. All right, that's actually pretty good, because it sounds like it's kind of a way out for the agricultural commissioner or the ag office, because we really don't feel that it's practical for them to try to be able to collect all the samples at the time of harvest. We can have a whole bunch, probably around August through September. There could be hundreds of farmers all wanting to have a testing done, and they probably don't have that, the staff to handle it. So this might be kind of a way out for this. Does anyone else want to comment on that, or does anyone else on the board have any opinion or questions regarding that solution?
It seems like a pretty logical chain of custody to me. I mean, if law enforcement's for it, obviously we don't have Rick here to express his opinion, but it sounds like Richard has talked to a couple different county ag commissioners previously, and this was the best option for them.
Yeah, and you're not really going to have an issue with us. We use private labs all the time for a lot of different testing, et cetera. So, I mean, it's helpful if there's multiple options, probably keeps things more competitive as well. So I don't see an issue with it.
The only thing, the wording that we showed earlier was a little bit off. There was a little mistake. You were showing me you corrected it during the lunch break. Do we need to somehow show that to make it more legit rather than what was up there earlier?
I don't think so. I think we're fine as long as, I think you were pretty clear in your summary.
Okay.
So I think we've got a pretty clear recommendation from Richard for the board to consider, and then we would work with him on making sure that his language is taken into account as we, move forward with trying to administer things.
Okay. All right. So just to summarize again, it would be up to the county agricultural commissioner to take the sample, but he is totally free to designate a private lab to do it for them. Probably sounds like a fair solution. Once again, does anyone on the board have a question about that?
Yeah, I remember Richard's comments where if he was going to sign off on that, he wanted, the ability to control that and leave that. The way you word it is great. We'll leave it flexible and let that individual ag commissioner decide how he's going to handle his county.
Very good. Before we make any motions, would anyone in the audience like to comment on that kind of solution that we have?
How do we change the language in this? I mean, no one in this room, we're lobbying for a change. But right now, we're just lobbying who's going to make the changes, because this is bullshit. I mean, you can tell it any way you want to, but that's what it is. We have no control of what we're raising, how it's tested, and how you're going to destruct it. I mean, how do we change the language here?
All right, well, if you're asking me,
I'm asking you guys as a group here, well, we're lobbying to change this, because, I mean, there ain't no way that this here is even, it ain't legal. I mean, we're raising a crop and they can take it for, why? I mean, how you going to test it? We don't agree how you're testing it. One person comes out, how you collected it. Tell me, somebody here, tell me how you're collecting it. I mean, you said you're going to take a little bit here, a little bit here. I mean, right here, Junior had the only good idea, harmonize the thing and then test it. I mean, every idea that we come up with, you guys are voting, oh, that's the end of it. We're lobbying to change these laws because, I mean, if we raise a crop and they destroy it because of this language here, it's bullshit.
Mm-hmm. All right, listen, good point, and I do agree with you. I think a lot of us agree with you. The issue here is that as the board, the California Industrial Advisory Board, we're not making the laws. We're only able to work with the laws as they have been written. So we don't have that flexibility to change the laws. You would have to lobby your legislator in order to get the law changed. We were successful. We had some laws changed recently with SB 1409, and that made the whole project a little more workable. And that's a good first step. Perhaps in the next year we can get more laws changed. I know I would prefer that this was treated like any other agricultural commodity and we didn't have to jump through all these hoops. But we are forced to work with the law as it's been written. As far as the procedures for, how's it going to be collected, that's what Josh was just talking about, what we talked about. We went over that in an earlier meeting, and we have actually adopted it. It is in the notes that I have here, and we'll be happy to share them with you, or you can, I think, get it from the CDFA. Am I right? Yeah.
Well, and within that, the sampling process that we're proposing is a homogeneous sample. So it's from all parts of the plant that are being sampled, 5 plants mixed together, pounded down, take a test on the THC. I don't know, what other parts of the process within the testing that, the public is suggesting we change, but like Larry said, we're operating within the law, but we do have some flexibility in terms of the protocol.
All right, go ahead.
Yeah, on that, Isn't the testing pretty much statutorily regulated within the language of Prop 64 as well as SB 1409? But I believe it calls for 6 inches off the top of the plant.
So,
Yeah, 1409 changed a lot of that.
right, SB 1409 changed that, and so now it says using department-approved procedures.
Okay. 1409 also called for testing to be done dry. There's no option for wet, just on the last thing that came up. Also, and before this screen here, you had gas chromatography as the only option on your testing, because then we automatically go into the physically changing of a cannabinoid. That was not discussed in the law. Just wanted to bring that point up because Prop 64 does not call for any cannabinoid to be converted to another cannabinoid, whether to pass or to fail. So I understand that the statutory items need to go through legislation to be able to do that. For instance, we're in Nevada this season because of the problems, and they do not test for THCA because the federal hemp law for 2014, as well as their own law, only calls for THC. They don't even use the word Delta-9, but THCA has a different name. It's a different cannabinoid, looks different when you draw it out, and contains an extra molecule of carbon dioxide. So it is physically changing it, and I think we're going to run into an issue that if we're allowed to change the molecule, you're going to open up Pandora's box here, because there will be science nerds, I'm not one of them, I'm more of a farmer, that can convert almost any cannabinoid into something else. And the law basically, from the way I understand it, was designed for the way Mother Nature produces that plant without man's changing of it. So I think we should look into that before we start making rules and start failing people on a cannabinoid that is not mentioned in the law. For instance, the law doesn't mention THCV, CBDV, CBN, all of the other precursors, and there's just many, many, many things in there. I think, that we need to put a little effort into this. I know for a fact that Nevada did, and that's why they said we have to follow the law. We can't make up our own rules as we go. Thank you.
Thank you. You want to?
What's the testing methodology in Nevada?
They test for Delta-9 THC only. They won't even tell you how much CBD is in your product.
It's not gas chromatography, though?
No, it's HPLC. Because gas chromatography automatically does that then. Heats it up, decarboxylates.
Yeah, I would also, had a comment about that. That says flame ionization detection, I wouldn't specify, if you're gonna specify. Whether you have to do GC or HPLC, and whether it's THC or THCA plus THC, I don't have an opinion on that. I don't know what the law says and how that's interpreted. I was curious in the comment on the sampling, that you only take female plants. It says do not sample male plants, but presumably you got seeds, you got about 50-50. The males are lower in everything, but they're still part of the crop. So if you're going to homogenize, so generally speaking, if you want to take a representative sample, you don't exclude anything, right? You sample those, maybe you could sample the males differently, but I wouldn't. They're all going to get mixed in. And that, again, that kind of adds to the burden of trying to meet that 0.3%. If you're taking out half of your crop and half of your crop is less than the other half, I'd consider whether that's the right way to go.
All right, thank you. Let me get back a little bit to the first gentleman's comments. You are right. In California law and in federal law, they only talk about THC. They don't say anything about THCA. Although in the 2018 Farm Bill, it does specify decarboxylated cannabinoid. Also, if we were to do the gas chromatography, it's going to automatically automatically decarboxylate some of the THCA into THC. So if we were to go by what you were saying, that would mean we would have to do the other method, HP, what's it? Yeah, HPLC, and then disregard all of the THCA that's in that. And, you know, I'd be all in favor of that, but I think that was something Michelle and I, we talked about a little bit in my original analysis. And we began to feel that that might not be the spirit of the law. Yeah. It's kind of a question mark in that regard. And I actually was hoping we could do it that way, but I didn't get a sense that that was really going to fly to do it that way. Plus, if the 2018 Farm Bill passes, it would require us to do the gas chromatography test on it. So even if we had it the other way, it would not be federally compliant. Yeah. Yeah, potentially. Well,
14 went way beyond that, 2014. It's optional, and it's mandatory for new states without a program.
all right, well, we should probably, well, we can all consider that. Does anyone else have a comment on that, in that regard? No? Okay, Matt?
The testing protocol that Richard and Allison have put together, is that still like open for discussion, or are we trying to close that and move forward on a motion?
Sure, I mean, at this point, what would likely happen is we would put together everything that's being combined and come back to the board for their discussion and confirmation before we actually propose any regulations. But at this point, I mean, there's still I guess there's not a motion yet, but the pending motion on the table of, you know, who collects the sample and what lab it goes to, which I think it sounds like the board has a fairly clear consensus on. But I think it would behoove us to take what's been done, put it into a draft regulation, run some things up the chain just to see what would actually be approved by the department and elsewhere before getting too far down the road. But yeah, I mean, there is still, we haven't proposed a regulation yet, and even once we do, it's still it can still be changed. So there's still
Yeah, I
a
think
possibility for further discussion.
those would be two points of dialogue going forward. So the method of testing, whether gas chromatography is preferred or if we just want to leave it open. And then the second would be including male plants in the sample. Because I don't think either one of those are identified in law, and they're open to the board. Okay.
Yeah, Richard, that question that was new, that I didn't even pick up on that about the male and female plants, you know, including both in the sample. Did you address that, or maybe I was asleep on that part?
No, Alice and I, we contacted 5 different states. We had that, I don't know, web call, whatever it was. And we drew these conclusions from programs that are already existing in other states. So that's how we came up with it.
Please make sure you speak into your mics, thanks.
Can I ask if I think Professor Lund, we need to ask you, is the drying method going to increase the THC content also?
No, the THC content is on a dry weight basis. I believe that's probably in there, so.
Well, you said that you used a drying agent to dry your samples, but what if you put them in an oven to dry them?
Doesn't matter.
Wouldn't matter.
So the dry, it's on a basis of the dry weight. So before you calculate your percentage, you subtract out the measured moisture, right? So if it's
Right, but
perfectly
the
dry, then
actual heating of the sample wouldn't matter.
depends on, well, generally to dry it, you heat it less than 100 C.
Okay,
And it doesn't start decarboxylating until, well, anything over 70 and you start to get some decarboxylation, but you can dry it without it. So
Okay.
drying it over dry ice doesn't heat it. Drying it at a desiccator, which is what we do, doesn't heat it. If you heated it, you could potentially convert THCA to THC. Yes.
okay.
But that wouldn't change much in the methodology as it's being discussed now, because both get measured by the GC anyways.
All right, any more comments from the board? All right, why don't we kind of move forward on what we've kind of agreed upon, and that's chain of custody. And I'll make a motion that we accept Richard's proposal to allow the agricultural commissioner to collect it, but being able to designate a private lab. Does anyone want to second that motion? Okay. All in favor?
Before we get there, so I just want to really quickly clarify what was proposed, just to make sure we're all in agreement. So what was discussed was that the county agricultural commissioner would collect the sample unless they choose to designate a private laboratory or a private individual to collect that sample on their behalf. That the farmer would be able to choose the laboratory of their choice as long as it was a department-approved laboratory. And then the farmer would be present for the sampling regardless. Correct? Okay.
Yeah.
Just making sure we're all on the same page.
All right, very good.
Did you
All
want to
right.
open up for further discussion or additional comments now that we have a motion?
Yeah, any other comments on that motion? From the board, from the audience? Okay, why don't we have a vote? All in favor, say aye. Aye.
Aye.
All right, anyone opposed, say nay. And anyone abstaining? Oh, okay, the motion passes.
Thank you.
All right, now we go to number 7, which is crop destruction. And not necessarily fun, let me get to that in my notes.
Okay, so,
Yeah, I'm sorry, yeah, by Joshua.
yeah, so Tom and I had presented 3 methods of, I guess one was an absolute destruction, and the other 2 were remediation, where the, if it was a protein crop, the seeds could be sterilized or heated so they wouldn't germinate, and they could enter the marketplace as long as they were below 0.3%. The same was with fiber, if it was being made into cloth or rope. As long as the products were not 0.3%, they could enter into the market. So basically that left us with, or legal, or the people at the top of CDFA didn't agree with any of the remediation, so we were left with, basically plowing in the crop or incinerating it, burning it, turning it into compost. So at this point, I think Tom and I just have decided that we'll just leave it open to the discretion of whoever's enforcing it, which is not clear at this time, without making specific instructions on how it has to be destroyed. So we started this proposal, but we're not proposing anything. We're not going to make any motion to change anything.
All right, Joshua Crescent, hey, earlier you were given the definition of destroy. But it's kind of boiled down to destroy means destroy, not remediation. Is there any flexibility within that? Because, destroy, it means set it on fire, it means plow it down, it means just chop it down. So it seems like, it's not really, an actual definition of what's to be done. So I'm hoping that the board can have a little flexibility on what we might be able to do with that.
Yeah, so without any further specification by the department or by the board, then it would be up to the individual county ag commissioner or sheriffs on what methods they would be willing to accept as far as ensuring that the crop was destroyed and not, moved into commerce. So, again, if the board doesn't want to make a recommendation on that and doesn't feel like they have something to recommend, that's fine. But then it just falls to the local authority's discretion. Go for it.
And really, the big challenge here is the law says that, and I know people may not agree with it, but that's where it has to get changed across the street and not here. We're only advisory. So it says destroy right now. It doesn't give another option. So.
Yeah, so if there are specific destruction methods that the board would recommend people use, if we do provide some sort of guidance to the local authorities, then it'll help to get additional consistency throughout the state. So, I mean, that certainly isn't a bad thing. But, you know, again, it's kind of what destruction methods are there that would be appropriate for hemp? You know, I'm not a hemp grower. I've never tried to plow under a field of hemp. I don't know how easy or practical that is. I've never tried to, you know, light it on fire in the middle of Tulare County, which I don't think could go over very well. So, you know, I guess that's kind of the question mark of what would be a recommended destruction method. And so if there is something that the board can provide or that, you know, experienced growers can provide as far as what an acceptable destruction method would be that would still ensure that that crop is in fact destroyed, is not moved into commerce, that's, you know, we're certainly open to hearing that and would appreciate the insight, just so that way we can have consistency from county to county.
All right, Josh Chase, I know you were talking about some form of remediation with it earlier. Did you come up with any ideas on the latter, what Josh Kress was talking about, where if it wasn't remediated or converted, had you come up with any ideas for actual destroying it?
Well, I think we are left with burning it, which I don't think the Air Board or most counties would allow. So basically, there was also, you could compost it, but I don't see how you compost, you know, hundreds of acres. Yeah, you can put up the last side. So I think really the only option will be probably chopping it up and incorporating it back into the soil. But I think we could just, I don't see why we need to write it into law. I think we could just leave it at the discretion of the sheriff or the agricultural commissioner to say, you know, you should burn this or you should incorporate it back into the soil. I don't see any reason to write it into law.
And David Robinson, is there anything in the history of what you've done with the sheriff department where people have to go out and destroy crops?
So because, you know, hemp is new, obviously, for us, we haven't dealt with it on the hemp side, but on the marijuana side, we've burned it. We've had plow downs. We've had burial in the local landfill, burial on the property site. So multiple, you know, other options for destroying the marijuana crop. So I can imagine that on the hemp side, it would be very similar to a destruction of, and all we're looking for is just something reasonable where it can't be, you know, sent out into the commercial field.
And in that regard, you know, believe me, everyone here, I just want you to know, none of us want, you know, the crop to be destroyed. You know, we really need to change the law on this. But in situations like that, if the sheriff department does have to go out, do they end up billing the property owner for that service?
There is a mechanism by which that can be done. You know, on the marijuana side, it typically involves a criminal case along with it. And so therefore, that's usually handled through the court process where the courts might order restitution for the fees that were involved. And so we would just track it. And so I don't, you know, that might be something that local ag commissioner's office would want to address if there were fees involved in that.
Yeah, so from my experience, I don't know of any situations in which we bill the grower for our time for, you know, taking a regulatory enforcement action, again, unless there's some sort of a fine involved or a penalty action by the courts. Beyond that, no, I don't know of anything where we charge an hourly rate for destruction, for taking that kind of regulatory action. But I mean, there are many cases where we oversee destruction, you know, where the state of the county oversees destruction of crops and fields. Again, you know, from our experience, it's always related to pests and diseases, not chemical content of the crop, but, yeah.
All right, well, why don't we hear, I know we have some unhappy people here in the audience, but why don't we hear from them, see what they have to say? Come on up.
Well, I just want to defer back to when we have these situations, like I said before, we're taking this hemp crop right now. What's paying the bills is the CBD oil. And we get paid by the percent of the CBD oil, nothing else. So the price point right now is $3.50 per point of CBD oil. Not THC, not CBN, so we're only interested as a farmer in cultivating CBD. And so again, we try our best, but we keep coming back to the same thing of like this little 1 percentage point. And there's so many variables that come into play all this, the testing equipment, how it's tested, what defines, a sample, well, a homogenized, well, was the equipment clean? You're not obviously gonna not use new equipment to homogenize these samples, so how, we keep, you might get something residual from the equipment prior to it, so it's all speculative, this whole point. And so this farmer has to risk his entire livelihood on, this isn't like a good setup, guys. I mean, to be honest, of this testing and how you're representing crop. It sounds pretty good. From my understanding, you're gonna take the whole plant, the whole thing, or you're taking sections of the plant. I'm still a little confused on, what exactly, you're testing. But my point is that when you get to what your sellable product is, when you extract this CBD, no matter what you have out there in that field, okay, when you go to extract it, let's say it's all less than 0.3. All right, when you extract it, you come up with a product that's 3% THC or higher, no matter what, every time. Then we remediate that into something else that's a 50-state legal product by diluting it with hemp oil or whatever to make it this marketable product that everybody sees. So explain to me why a farmer that would wind up extracting a product that's, say, 0.6%, let's say he had double the THC he was supposed to have. Well, there's not much between 0.3 and 0.6. There's no harm done. There's no jeopardy to the society. But a farmer's got to risk losing everything over that. And that's just ridiculous. To even insinuate that we're trying to do something that's criminal to where that we're at a point where we just, like I said, everything's on the line on this test. Nobody's trying to grow pot. We couldn't sell it if we want to. You can't take the whole market, the cannabis market out there demands 20% or higher flower. So you can't take something that's even 2 and 3%, THC and be able to sell it out there on the market. Nobody's going to buy it. Nobody's even going to be confused by it. Nobody's ever going to get high from it, but yet the farmer has to bear this burden, And, so that's about what I have to say about it. And I continually run into this, and farmers want to know what to do, and I don't know what to tell them. I'm like, well, you might as well take your money down to the casino and lay it on blackjack right now because you're running about the same kind of odds. So, I'd say any farmer who wants to get out there and get in this business right now, the way things are kind of shaping up, it's possibly they could be like in a crop loss situation without, having any kind of intentions of even being there. So, anyway, that's all I have today to say. Thanks, guys.
All right, thank you. Justin?
Justin Eve with 7 Generations Producers. We're an organic farm here in Sutter County. Just some clarification real quick on the destroy or the destruction clause you guys are proposing here. If the definition by destroy is remove or manipulate, change, whatever under the definition of destroy, and then the county commissioner is going to be in charge, or it's up to them to decide on the destruction process from there, from my understanding, just for clarification. And then, because we are familiar with the destruction of proprietary information, you pick up paper and then they get, recycling fees for that back to the farmer. So the question is, if the commissioner allows destruction of a crop or approves the destruction of a crop, and then that crop is removed, destroyed, whatever the definition is, and a third party is deemed the organization to take that crop away. And then it's essentially up to the commissioner to make sure that the third party properly, quote unquote, destroys that product, right? But after that product is handed over to whoever's in charge of destroying it, it's essentially out of their hands, and then the agreement would be between the commissioner and the destruction company, correct? Just like we're destroying paper and recycling, is that understood how it's the commissioner's responsibility to make sure that it gets destroyed? Not necessarily the agriculture commissioner office that destroys it, but they just have to make sure it's by definition destroyed, is that correct?
David, if you want to comment on that, on how things are dealt with the county level, yeah.
You know, I can only speak to it from the marijuana perspective, from the law enforcement side. You know, destroyed to us is pretty simple. Landfill, burn it, plow it under, bury it, you know, and so it sounds like the example you're using is now you're interjecting a third party that might use it for another use, which is then, to me, would not be destroyed.
Well, if whatever
It's gonna be used for something else, then it's not destroyed.
Well, I'm saying however the commissioner, that seems like that's who it falls on. That by definition, destroy, whatever that is, it's their responsibility to make sure it is destroyed. Whatever that, however the definition is done, however they do it, as long as it's in their eyes destroyed, changed, altered, tilled in, whatever that is, that's satisfactory, is what it sounds like.
So, speaking from an agricultural perspective and ag enforcement, I'm not aware of any situations in where we've had third parties involved in the destruction of plant materials, other than perhaps licensed green waste people for certain crops. But generally speaking, it's, if it's something that requires burial, it's either the commissioner or the grower under supervision of the commissioner that's taking it to the landfill and it's supervised burial. So yeah, I'm not aware of situations, at least in the ag world, where that kind of thing is done. It might be, but nothing that I'm aware of.
But since you guys aren't defining it further, and you're leaving it as the letter of the law says destroyed based on the definition in the dictionary, then that is applicable based on whatever the commissioner agrees upon, right? I mean, if the commissioner says it's destroyed, sounds good, looks good, you're good, right? I mean, that's what you're saying, right?
I think that's more of a legal interpretation.
Right.
You know, by a local county council or some other attorney or something like that, but, you know.
Okay, sounds good. And then one thing that I've heard a couple people ask about, I don't mean to go backwards, but you're talking about the testing procedure, how much of the plant, he said leaf, seed, stalk, all the things. I don't know, I didn't see it in there if it was specific, 1/3 or by weight or something like that. So I think that kept coming up. You know, they want to know how the procedure is and then how much of that plant, by definition, weight, 1/3, the whole plant. So, and then so is that 100% of the plant
So-
from the stalk up or from the root
Right,
base
so
up?
as with every other meeting, we'll go ahead and we'll post everything that was presented or discussed here today online after the meeting. So that, including what was, the cleaned up version of what was presented at the past meeting, will be posted online after the meeting today for you guys to look at.
Okay.
That'll be
Thanks
available.
again. Appreciate it.
Quick comment to Justin's remarks. If we don't make any recommendation for the way it's destroyed, it will be in the hands of the County Agricultural Commission, and it's just really up to him to decide if it was destroyed or not, so they can do it any way they wanted. Would that be correct? Yeah.
That's what I think you're correct.
All
It's
right.
at the discretion of the agricultural commissioner or the local law enforcement to how it's destroyed.
All right, and we in the state wouldn't have to follow up on any of that, would they? It would just be the local county.
So the state, as a state agency, we're obligated we work with the county agricultural commissioners and we provide guidance and do our best to provide uniformity in how rules are applied across the board, and we provide trainings to the counties and things like that. So we, certainly, especially if there's when we're getting into a new crop and there's destructions or really any kind of major enforcement action, generally the state is involved in that alongside the county, alongside usually scientific advisors and people who are subject matter experts to make sure that we're not just complying with laws, but doing things in a way that makes scientific sense as well. But yeah, so even though it's the county's responsibility and the county's discretion, CDFA would generally be involved in those situations. And the counties generally rely on CDFA for assistance, especially with something like, destroying someone's crop.
Yeah,
Take
Larry,
that pretty
a
seriously.
comment here. Josh, and I'm glad I asked him to help me. He really led the whole focus of this thing, but my focus was, from the get-go, is how could the farmer recoup his input cost if there's no intent of his or no fault of him that the crop went hot? Well, that's what we put together, I think, through really Josh's efforts. And I was just thinking now, some of the comments from the audience, and this is a new crop. Would there be a possibility, and again, thinking of the term of a farmer trying to recoup his input cost, he only got the input, and then he has to destroy it on top of that, to, disc it up. But it drives me crazy. But I'm thinking, is there an insurance, or could there be an insurance product out there that would reimburse that farmer for his input costs, or at least where he could come out whole and not go backwards on it? I don't know.
McConnell Hemp Rider. The McConnell Hemp Rider encompasses farm crop insurance. So when that gets passed, that may be a possibility. But I'm sure the insurance companies are going to avoid it if you fail because of high THC, or probably any other reason that they would have to pay you, for those that have dealt with farm insurance before. Sorry, I didn't mean to interrupt you while you're taking that there.
It's just a thought. I mean, some
Sure.
way to
Completely
survive.
understand. On what we have up on the screen here, I believe it was 3 or 4 slides ago, the last sentence, the following destruction methods to render the final product less than 0.3% THC are acceptable. Was there supposed to be something, the following part? Now, of course, that's going to be your tilling it under, which is not a good idea. It'll wreck your farm equipment. It's very fibrous. Burning it seems to be the most efficient way, and I would suggest that everybody can participate by rolling them all up into individual joints and burning them, one joint at a time. I know it sounds funny, but so do all these rules. I mean, we have 346 pages of rules and regulations by the BCC that the industry takes about 30 seconds to figure out a way around them. If we do the same thing with hemp, we're going to drag this on for years. We need some common sense into this thing, and we're working towards that. It just seems like each time it gets more confusing. Those are my comments. Thank you.
No, I agree with all this, although I might want to add that other states are growing industrial hemp for fiber, for seed, and for flower, for CBD, and not all of their crops are being destroyed. You're testing it too hot, so I would say it's not.
Infrastructure for fiber. Kentucky does. Other states do. Oil is the business on the West Coast.
Right, but other states are growing it for oil too.
There's an infrastructure for fiber.
Did that faster growing corn than hemp if you can't produce the oil out of it.
Yeah, CBD oil is what pays the bills right now. And when you're talking about destruction, there is things that we could do, like hempcrete. It could be utilized in some way if there was some kind of infrastructure to deal with it. Again, I just want to encourage to be the first state that just says, okay, yeah, we're going to do post-harvest analysis, but it's going to be advisory, It's just like, okay, we get an idea, okay, it's not cannabis. The guy's not out there growing, 15%. So you try to work with your cultivars, you get it in, but be the first state that says, because it really doesn't make any sense. Because when you have a legal product that's, coming out of the machine, it's 65% CBD, and the fact that a farmer has to win or lose everything is just, it's already 3% THC. It's nothing you can put out there on the market without going through the dispensaries. So it has to be remediated to a product that can go to the public. So it doesn't, there's no sense of itself. It's not change, it's just a minute in percentage. So use it as an advisory. Convince these politicians to say, okay, this is the way we're going to go, but what matters is what product is going out to the general public. And you just adjust it. To change something from, it's so minute. And we were talking about even it extents where you say, all right, the guy's double the THC, let's say. And this is kind of the way Oregon does, is that, we do the 30-day, pre-harvest. And if you call up the Department of Agriculture and you ask them, well, what about post-harvest? Well, that's not, and I've called them up and asked them, what percentages are you comfortable with? Are you comfortable with 1% flour, 2% flour, you know, coming off these plants, and they say, yeah, we're fine with that. That's post-harvest, you know? So what matters is at that point, if you have a hemp handler's license, what you're sending out to the public, is that less than 0.3? But so we're getting caught up on all these details, or these minute little things that really don't matter. You're not creating one, you know, you're just creating a system that'll fail. Eventually, you're gonna have a bunch of farmers, you know, sitting there, they get crops destroyed, they're bankrupt because of, you know, I've already been through the growing pains with one state on this, of like going one direction and backtracking up. And what I'm trying to do is maybe help some people that, you know, will listen and try to do it the right way, so that you don't have 4 years of growing pains.
Yeah, no, listen, I agree with you. I think we all agree with you here. You know, everyone working here, and we were even, what Joshua was trying to do was figure out a way, as we call it, remediation, a way to be able to use it, but as per the definition that we found out today, destroy means destroy.
Yeah. Well,
Yeah, can I comment again? So, what was it, 2 meetings ago, we presented these 3 alternatives to destroy it, and I guess reconstruct it into a product that was below 0.3%. We sent that up to people up top at CDFA, and they spoke to the legal counsel, and they've denied that. So I guess the only alternative now is to challenge that ruling or process or whatever, or to amend the law and write legislation to make this right, or. But
Yeah,
at
because
this point, we can't, we've already recommended something and it's got shot down.
Sure.
And so we've kind of I came to the conclusion that it's probably not worth making some recommendation, like it's got to be plowed under, or mowed and incorporated back into the soil or burned. I think it's just kind of leave it open, I guess, at this point.
The fact of the matter is, we're working within the legal framework of the law. And
Yeah.
it says 0.3%, it's tested for harvest, and if it tests hot, it has to be destroyed. And there's, instead of, with the exception of redefining destroyed, there's nothing that the board can really do to change that.
Sure.
And our hands are as tied as, you know, yours or any farmer's. I would like to suggest that we accept Black's Law Dictionary's definition of destroy rather than Merriam-Webster, which is a little broader. For instance, as used in policies of insurance, leases, and in maritime law, the term destroy is often applied to an act which renders the subject useless for its intended purpose, though it does not literally demolish or annihilate it. To destroy a vessel means to unfit it for further service, beyond the hope of recovery by ordinary means. In relation to wills, contracts, and other documents, the term destroy does not import the annihilation of the instrument or its resolution into other forms of matter, but a destruction of its legal efficacy, which may be by cancellation, obliterating, tearing into fragments, etc. So maybe some lawyers can work within that definition.
Right.
And help us out.
Yeah. Yeah, exactly. Just leave a farmer an out somewhere
Yeah.
in there to even recover at least his investment costs in some fashion.
I totally agree with you. Maybe we'll have a big hemp biochar plant
Right.
built in the state. I don't know.
Something, because you're going to run into this stuff. I've already seen it out there. It's very disheartening. So yeah, that's all I do is I want to say is just I encourage people to take a different stand, you know, on this thing until the federal regulations get in. You know, just try to have a different approach.
Yeah, is there any way, as you kind of ran it up, sorry, you ran it upstairs, it was the CDFA's legal counsel that defined it?
It was the department. I'm not going to go into specifics on who in particular, but the department as a whole. And one of the things that was pointed out is we don't allow remediation for any crops that are destroyed, and we destroy crops for all kinds of reasons. So that's not something that, unless there's a system that it can be moved into, you know, that's not something that's done at the department, and there's nothing there to really work with at this point. So no, destroy is destroy, as David was saying. For the sheriff's, destroy is destroy. If you're required to destroy a crop, regardless of what it is, it means to plow it under, burn it, whatever. Yeah.
When you say department as a whole, there's no specific person or persons, it's the whole department made this
Yes.
decision together.
Yes.
what if you have, you're growing a farm, you're doing research, and you have 5 plots and one goes hot? You going out, the people gonna come out and try to destroy the whole thing? Like, all the plots? Or just the one? Haven't seen that really defined that, you know, and when you're dealing with genetics, and you're coming out there and if you're not taking a homogenized sample of the entire field, because that's an accurate representation of your harvest versus one particular plant. Just like genetics in anything, you know, sometimes there's variables. That's how all this stuff got created to begin
Right.
with.
It's a good question.
Yeah, so, thank you for your time, guys, and listening. I'm sorry I wasn't at those previous meetings. You know, I've been trying to get here, and you know, I'll ramble on about hemp all day. It's been my livelihood for the past 4 years, and that's why I live every day. So,
All right, thank you.
thanks, guys.
Thank you. All right, next person.
Josh, Webster's definition, first word under destruction is repair. So if I cut that plant, the top of it off, and process it into CBD and THC, I have repaired that plant. Point of law, that was your idea, but look under the first thing it says, it's something that can't be repaired. So if I repaired that plant, then that crop don't have to be destroyed. Is that right?
I think, once again, you're asking for a legal attorney.
Legal, yeah,
opinion.
that's a point of law, but in the point of law, it says it only has to be destroyed if it can't be repaired.
If you possess something more than 1% in law enforcement size, it's going to be marijuana.
Well, it's not marijuana, I'm just going off point of law. It's argumentative.
Yeah, you're asking a legal opinion again.
All right, thank you. Next gentleman.
Hello, Junior brought up a good point that I hope could get addressed in the future, and that's regarding the different plots. There's different strains. But as far as destruction, environmentally, it's obviously there's a financial loss, huge. But you know, the tens of thousands of gallons of water that gets wasted to produce that is really saddening. And as far as the destruction, how to destroy it? I think burning it may sound like the easiest way, but I hope that's the less likely way to do it, as far as, because it's going to produce a lot of pathogens and stuff into the atmosphere. So I hope that's like kind of last resort if it needs to be destroyed.
For the record, what was your name?
Chris Kyle.
Chris?
Kyle.
Okay, thank you.
All right, any other questions regarding this? I think we're basically, as the board, we're not going to make any recommendation. We're just going to have to, I don't think any of us want to be on the record for making a recommendation like this. So we would have to leave it up into the hands of the county, or each county to decide what they want to do. And who knows, maybe they'll be creative. I don't know with the whole thing. All right, so we might as well go up to the next agenda item, which will be number 8. Actually, this is a little nicer. Discussion on development of an agricultural pilot program. And who's up for that? And that is Joshua Chase.
Okay, I was the only person that wanted to look into this at the last meeting. So I guess to start it off, we had the SB 1409 was signed by the governor recently. And in that, as part of the registration program established pursuant to this division, the department may establish and carry out by regulation an agricultural pilot program pursuant to Section 7606 of the Federal Agricultural Act of 2014, or the Farm Bill of 2014. So moving on to the next slide, it's the 7606 is the legitimacy of industrial hemp research, or the Farm Bill. And go to the next slide. So what the pilot program can be is an institution of higher education or a state department of agriculture may grow or cultivate industrial hemp. Industrial hemp is grown or cultivated for purposes of research conducted under an agricultural pilot program or other agricultural or academic research, and the growing or cultivation of industrial hemp is allowed under the laws of the state in which such institution of higher education or state department of agriculture is located and such research occurs. So I guess we currently have both of those. We have a law that allows us to grow industrial hemp. We're still waiting on the forms to apply to grow it, but we do have a law. We do have a agriculture, or we have a Department of Agriculture gathering data and administering this program. So I think at this point, we kind of already have a pilot program. We are gathering data, but let's move on to the next slide. So these are specific definitions of an agricultural pilot program. The term agricultural pilot program means a pilot program to study the growth, cultivation, or marketing of industrial hemp. In a state that permits the growth or cultivation of industrial hemp under the laws of the state, and B, in a manner that, 1, ensures the only institutions of higher education and the State Department of Agriculture are used to grow or cultivate industrial hemp. 2, requires that sites used for growing or cultivating industrial hemp in a state be defined by and registered with the State Department of Agriculture. And 3, authorizes the State Department of Agriculture to promulgate regulations to carry out the pilot program in the state in accordance with the purposes of this section. So when I read this, we basically already are a pilot program. We're in a state that permits the growth when we look at Section A. And B, we're only allowing institutions of higher educations and the State Department of Agriculture are used to grow or cultivate the industrial hemp. Those are the only ways we are going to be able to grow hemp in California. And then secondly, it requires that sites used for growing or cultivating industrial hemp be registered or certified, that's what we're about. I've heard that we're going to get a form here in the next week or two, and then that's going to go through a process, 45-day process. And then third, we're promulgating regulations right now. So I think we already are a pilot program. Let's go on to the next slide. So these are the recommendations. Or what would be the purpose of this pilot program? The purpose of the CDFA pilot program is to create a federally compliant program for California farmers to research the growth, cultivation, and marketing of industrial hemp in California. Secondly, this will open the doors to new markets in other states and countries, or counties or countries. Let's go to the next slide. These are questions. What would be the role of the CDFA? I would think the board would expect the CDFA to provide farmers a pathway to grow federally compliant industrial hemp, as well as gather data on growth, cultivation, and marketing of the crop. Let's go on to the next slide. Recommended data to be collected under an ag pilot program. The pilot program will initially only gather data from the registration and destruction forms. Additional research can be added as a private or public sector deems it necessary. So right now it'd just be how many farmers are growing hemp, which we'd just gather from the forms that the farmers fill out. 2 would be how many acres are being grown. We can get that off the forms. 3 is the acreage for fiber, grain, oil seed, full spectrum plant oils or other industrial purposes. and get that off the form as well. 4, what varieties are being grown. They're going to be certified varieties that I think the forms you put on the form. And then actually the 5th one is how many acres had been destroyed. I'm not sure exactly how we're going to gather that, but we had proposed a form a couple meetings ago, so possibly we could gather that data as well. So I think that's the last slide. Is there another one? Yeah, so I think we already are a pilot program without specifically saying changing our name or changing the CDFA's name or the name of this group or whatever. But if we're not, I would propose that we call this the California Agriculture or Hemp Pilot Program. I think that's enough to be considered a pilot program. From what I looked at, I don't know if there are any questions about that.
Yeah, so on one of the slides, did it say it could only be grown at an institute of higher education?
That's part of, 7606.
Which it seems like right now, right? Can it be a research institution, which seems like they would be different?
Correct. So what Josh here is referencing is what's in federal law, which is, the 2014 Farm Bill, Section 7606, which allows for industrial hemp to either be grown by a Department of Ag or by an institution of higher education as defined in federal law. California's definition of an established agricultural research institution includes the federal definition of an institution of higher education, but it also includes a very broad definition for other research institutions as well, besides those that would meet that federal definition, and those are not required to register with CDFA under California law.
And so those people growing would be part of this, not part of this, or?
If they register?
I mean, if
Yeah.
is there a way that the people growing right now under the research organization who aren't with higher education could be part of this? That's what I'm asking.
So they could register voluntarily. It says they're not required to. That doesn't prohibit them from doing so. If we can go back a couple slides. One more. So this is the section that's in the Food and Agricultural Code regarding this, and so it says as part of the registration program. And so when we asked the sponsors what the intent of this was, they said that the intent is that every participant in the registration program would be a member of this Ag Pilot Program. And so if someone who was exempt from registration but chose to do so, they would be also part of the Ag Pilot Program. And so the question, which I think Josh kind of lays out in the last couple slides there, is what research is CDFA being asked to do as part of this agricultural pilot program? And that research is collecting data from registered growers. And then the question is, what data is CDFA asked to collect from registered growers? Most of the items he pointed out are on the what's laid out in the law as far as the requirements for the application for registration, and so the application is required to be forwarded from the commissioner to CDFA. And so we would get most of that information. One of the items that he included, which could be up for discussion by the board, is the purpose of that crop that was removed or will be removed via SB 1409. So that will no longer be a required part of the application. However, if the board would like us to collect that information, we could do so through regulation or through voluntary providing of it. But if there's any additional information or if there's any kind of post-harvest reports or any other data that the board would like CDFA to collect as part of an Ag Pilot Program to be able to provide that agricultural research component and be able to report out to the board, to the industry, to the state, to whoever, that's kind of where we're asking the board, what other information would you like us to collect? Because obviously we'll get everything on the application itself, but what else will we be getting?
Well, I think part of the reason they did this was because people were, quote, doing research, and it wasn't through an institute of higher education, and they were kind of against federal law. And by doing it through the Department of Agriculture, that aligns more with federal law. It would prevent federal agents from kind of claiming that what you were doing was illegal. Also, other states have interpreted that whole thing pretty broadly. For example, in Kentucky, they have their Kentucky Department of Agriculture, and what they're basically doing is they're allowing, just about any farmer to register with them, and they're allowing those farmers to grow the hemp basically for commercial purposes. And therefore, all of those farmers are now federally compliant. And also the Kentucky Department of Agriculture is able to get DEA permits to import industrial hemp to get the certified strains from other countries. So it's generally broad, and in the past, we've asked, the California Department of Agriculture if they could be a part of it, and I think generally, Josh, you've said in the past it's not something you've ever done, or it's not something that the department really does or has never done in the past.
Does what?
Kind of do research or have a research program for industrial hemp or
Correct.
things like that.
Yeah, so CDFA, generally speaking, does not conduct research. And we have a few programs that might have some research projects or research components. We fund research, but generally we don't conduct research because that's what we have the University of California system and cooperative extension for. In California, that's the research arm of the state is UC Cooperative Extension, as well as the other universities as well. But, generally ag research is done through cooperative extension, which Van can represent and speak to, which is, of course, not the case in every state. Every state's a little different when it comes to that sort of thing.
So does the department currently think that they're running a pilot program? Is that the department's opinion?
Well, so if we can bring up, it's still up, okay. So what the law states is that it requires or allows for the department to establish a pilot program by regulation, correct? With that. Anyway, so what we would do is we would establish it by regulation, and we would establish that registrants are participating in a pilot program by regulation. And if there's nothing else that's being asked of it, that's not a whole lot of a regulation. So that's not a very complicated procedure there. And even if we're asking for post-harvest information, I don't think that's that complicated. But we would do so via regulation just to make sure that we are clear that again, if the purpose, which Josh stated, is that the intent of this section that's up here is to provide growers with some assurance that they are complying with federal law or the ability to be better in line with federal law, then we want to be clear about making sure that we are aligned with federal law and be able to put that into regulation stating, what the components of the pilot program are. I think would give more credence to that.
Would those regulations be based upon the board's suggestions?
Yeah.
Okay.
Yeah, well, that's what we're discussing now is what does the board see as the needs for what information should the department be collecting as part of an agricultural pilot program? And again, if all we're collecting is the information on the application and then reporting that out at the end of the year, that's pretty simple.
Well, it seems like the destruction information could be collected from the county ag commissioners as they destroy any harvest.
Correct.
But I'm also looking at section 81009 of SB 566, which says that not later than Jan 1, 2019, or 5 years after the provisions of this divisions are authorized under federal law, or whichever is later, the board, in consultation with the Hemp Industries Association or its successor industry association, shall report the following to the Assembly and Senate committees on agriculture and the Assembly and Senate committees on public safety. A, the economic impacts of industrial hemp cultivation, processing, and product manufacturing in California. And B, the economic impacts of industrial hemp cultivation, processing, and product manufacturing in other states that may permitted industrial hemp cultivation. So I think it would be my suggestion is that whatever information we're gathering in the pilot program can feed into that report. I think there has been a very gray area for established agricultural research institutes and any MOU participating farmers right now in California, whether they're federally compliant or not. And there's confusion at the local level from county ag commissioners about what their enforcement of that is. And I think they're also, reaching out to some of these agencies. And, just to be blunt, I think most of the people that have crops in the ground in the state are currently working with established agricultural research institutes, and there's a lot of R&D and data gathering that's going on. So whereas I'm totally for these institutes being able to sign up as registered growers. I'm also suggesting that they and somehow be grandfathered in or work directly with the department or the UC system to develop some research protocols and all this.
Hey, Matt, just, I believe the section that you read actually isn't in effect until federal law changes.
Yeah, I think it's as it becomes compliant with federal law. So, to my mind, that took place with the Farm Bill.
It's actually in the latest version of the Farm Bill if I was reading it correctly, the latest version of the Farm Bill, the 2018 version.
Mm-hmm.
Once that is enacted, then that one actually goes into effect.
All right, I'm not sure if we have anything to vote on or recommend at this moment. It seems a little vague.
Yeah, I mean, so regarding Section 81009, I mean, thank you for bringing it up, Matt. I think it's something that was worth looking into for the department. We have not been requested to provide anything to the Assembly or Senate committees at this point. So, you know, I think it might be safe to assume that the intent, since the law changed to remove the federal authorization and make the law simply operative as of January 1st, 2017, I think it could be easily interpreted that it would be 5 years after that date, which would give a few years before that report is due. But we'll follow up just to see with our legislative folks, just to see if there is something that's being expected of the board before the end of the year. Hopefully not. But yeah, again, your comments are appreciated.
So would the department then be willing to hold a DEA permit to bring seed in the state? Part of this pilot program?
So CDFA does not import or distribute any plant materials of any sort. Again, that's something that's a service that's performed by the UC, and the UC does it very well for a number of different crops. There are a lot of crops that require some type of a controlled import permit to be able to import. Whether or not CDFA would be able to provide that service, I don't know.
Okay.
If that's something the board would like CDFA to provide as part of an agricultural pilot program in importing plant materials and then deciding who gets them and how to distribute them, I mean, that's something we can investigate. But at this point, we don't do that for any other crop. You know, if you want to import grapevines, you contact UC Davis or USDA, and they're the ones that hold the controlled import permits for grapevines. So, you know, for us, generally, that's the way that things work in California, which is not the way they work in other states. But that's something that if that's a service that the industry would like CDFA to provide as part of a pilot program, that's something that we can look into further to see if it would be something that could be accomplished.
I think that would kind of fall along more the Kentucky model, right, that Larry was talking about.
Yeah, and again, different states do things differently. I'm not that familiar with how things are set up in Kentucky, but a lot of times those types of services are actually provided by the department for other crops, and a lot of times, actually in other states, sometimes testing services are performed by the university, whereas in California, CDFA is the one that does official tests for like diseases and things. So every state's a little different, and California's obviously very different from everybody else. No one else has 58 ag commissioners either.
Right.
So we're definitely different from everyone else, which is always fun in those interstate meetings. But yeah, so that's something we can investigate further, and we'll certainly also work with the UC to investigate further on there and to see what types of services the UC might be able to provide as well.
Can we initiate the pilot program before we have registered growers?
It's the law states as part of the registration program.
Okay.
So I would read it as part of the registration program.
Okay, so is there anything we can do as a board to set up the pilot program before we're actually registering growers, or are we already doing this?
So as I've said before, anything that the board thinks that they want CDFA to do, or any regulations they want us to specify, anything that they want us to discuss, the earlier we have those conversations, the better, especially if we can work through some of the details before it's absolutely needed. So if the board would like to discuss those things, we will mention the status of the registration fee and how things are hopefully progressing in a little bit here. But, you know, as far as if the board would like to see something else in addition to what Josh has put forth here today as far as, the minimum requirements of an agricultural pilot program, please, speak up now. And even without a motion, it's something we can investigate. So if there's something the board in general would like us to further investigate, we can do so.
Yeah, I mean, I would like to recommend that the CDFA help us get the DEA permits for farmers to import. I mean, that's, you know, the majority of the registered seed is actually outside the country. And without being able to import it, it makes it very, very hard for farmers to be able to grow hemp. So unfortunately, it seems like the university system kind of chickened out, and they don't want to do it. So, you know, it would be very beneficial if the CDFA can do it. And you
have
wanted
any
to say
comments
something,
on that?
Valerie?
Well, I wouldn't say, I can't speak for UC, but the Cal State system would like to do it, but they have to be very cautious about meeting all federal requirements because they are partially federally funded. And that's why they declined to go forward with it. So once that's taken care of, I can't imagine they would be particularly hesitant to do research. I think that would be going forward, so.
Can either of you speak to any kind of preliminary conversation? I know you probably can't go into a lot of detail, but any kind of preliminary conversations that are going on that you see about maybe future plans or what, if there's anything that's in the works?
Well, at this point, no. In fact, we were very explicitly told we couldn't do anything until this got taken care of. There was a nice letter that came from the chancellor for all of us. So at this point in time, not until there's something very clearly laid out, we can't move forward.
What's going on the 30th of November with the UC and their discussions with hemp?
Yeah, so UC is moving a little bit quicker, but still, you know, very slowly. So we have a few agricultural specialists and advisors who are interested in doing tests on UC land, and it looks like they're going to be able to get some seed in the ground this winter or spring in Southern California at some of the centers down there. It's not a done deal by any means, but there's people moving forward on that and working on that. November 30th, we're hoping to have some hemp meeting summit type thing at the UC Davis campus. We're still working out the details. Most of you will probably receive an email invitation at some point as we're trying to get a broad group of people from industry. I mean, and just to sort of say where this is coming from, you know, the person within my organization who's really leading this is the Chief Innovation Officer, right? So it's not coming necessarily from the plant side or from the economic side, it's sort of coming from the innovation side. And that's, I think, where the university is seeing it right now. So I would say things are starting to move, but we're still pretty cautious.
So 2 quick points. So first off, with the meeting on the 30th, let's discuss just to make sure if there are going to be board members present, we don't want any bag leaking violations. So let us know so we can work with you just to make sure there's no concerns there. Shouldn't be, but just in case. And then it sounds like there's kind of a consensus on the board for CDFA to further investigate importation of hemp seed and hemp materials. So that's something that we'll investigate on our end. We can have a discussion on that about maybe next agenda items, and we'll work with Valerie and Van to try to make contacts with the UC and CSU systems on that as well.
Should we open this up to public comment now, or?
Can I make a quick request? Josh Chase, are you the only one working on the pilot program
Yeah,
subcommittee?
nobody else wanted to.
Could I
work on it
join? I
last
wasn't
meeting.
here last meeting, so be willing to volunteer for that.
Yeah, that'd be great.
All right, well, let me ask you, do you guys want to research this a little bit further and come up with a report for our next meeting?
Yeah.
Okay, so designate you, do you be okay with that, Josh Chase?
Yeah, sure.
Okay, with working with Matt, yeah, and have some recommendations for what we might want to see the CDFA do for a pilot program.
You okay with that, Josh? Chris?
Yeah, so on that, yeah, that's fine. I think just again, as usual, coordinate with Michelle. But we'll coordinate our investigation and with your guys' report back at the next board meeting. So that way we can kind of coordinate and make sure we're all working together and, you know, coming up with something that's can be reportable. Cool.
All right, anyone from the audience like to comment on the pilot program in Law SB 1409? All right, no? Okay.
We got one person.
Oh, we do? Oh, okay.
Justin with 7 Generations Producers. We're a organic farmer in Sutter County. Just maybe speaking to the pilot program for Josh and Matt, it looks like it could be an opportunity to kind of get a direction for the pilot program. I know that most states' pilot program is a direct MOU with the state agriculture division or whatever it is directly with the farms. And so the request, Josh Crest, about the seed importation, that's something that the state's actually gone out on the limb and supported those farmers directly. So, you know, maybe just the recommendation there, or, you know, to have the whole board look at the pilot program. If it's a more of an opportunity for the state to support the program, getting outside of the regulation, or versus, you know, being continually regulated under the pretenses that we're already regulated under. So I'm not sure about the opportunity, but I've seen that the MOUs are direct partnerships with the farmers. The Agriculture Commission or whatever it is a direct partnership with the farmer. So whether it's more of an opportunity and easier to go that road, or versus going to be tighter regulation going outside of that pilot program, the development of that, that's a recommendation I look at for the advisory board. Thanks.
All right, next gentleman.
Accepting questions on just SB 1409 or 81007. I have a question on 81011.
So right now, we're talking about the agricultural pilot program. Next, I believe
Well,
it's
that
the
actually
agenda.
would be involved with that,
Okay.
81011, although I'd be more than happy to do it just during open mic time or
Okay.
public comment time.
Yeah, we still have an agenda item regarding changes to state and federal laws and identification of
Oh,
future
wait.
board actions, so that probably would tie in with that. Yes.
All right, any other comments from the audience? Okay, why don't we move?
I gotta, in order to like kind of get things rolling and move things up the chain here, I'd like to make a motion now to establish this California Industrial Hemp Pilot Program and just see what the people up top say about it, and recommend that we start with the stuff that I recommended here, just the stuff from our forums that we're gathering, and just, you know, get their opinions and see if we can get this thing rolling sooner than later. So can I make that motion, or?
So your motion would be for CDFA to start working on regulations to establish a pilot program based off of your recommended components here in the presentation of the information being gathered and being reported back to the board, correct?
Correct, yep.
Yeah, I'm okay with that, but I'm not exactly sure what you're recommending. It seemed like it was more.
I'm recommending that we start a California Industrial Hemp Pilot Program. That's in the simplest terms, that's what I'm recommending, and that we start with gathering the information that we're gonna gather from the forums that we're putting out, and then we can, as we see needed, we can add agricultural component, or research components that we'll probably have to bring in the university system to conduct.
Actually, yeah, I think you're right, because it says in the law, as part of the registration program established pursuant to this the division, the department may establish and carry out a regulation and agricultural pilot program. You're basically saying that we recommend that they actually do it.
That they start,
correct?
yeah, that they start exploring this and developing it, yeah.
Okay, or you want to make that, say that again, make that motion one more time? Sorry. You're making that motion.
Yeah, you can reiterate it.
So the
yeah.
motion was the CDFA draft regulations to establish an agricultural pilot program in accordance with 81007, and based on the components of Josh's presentation, which if we scroll down a couple slides, the components of his presentation are there.
Okay, I'll second
One
that
more.
motion.
Yeah, so an agricultural pilot program in which CDFA would gather the following information and report back to the board and public. And that's the
Alright.
information, which is information that's on the application.
I'd like clarification before you vote on that.
Okay, well then, before you make comments, we've got a motion. Do we have a second? Does anyone want to second that motion before we
Alright.
take comments?
I'll second it.
Okay, Lawrence did, okay. There you go.
For University of Davis, you said you're going to get involved. I talked to John Pasco and Sue Sover in the equine industry about the same thing, and, are you, when you're talking about including Davis, are you gonna include the equine, of University of Davis in this pilot program, or this, or that's what they were talking about, they was gonna get the university involved?
What I was discussing was one specific meeting, which the list of the people who will be involved is still developing. So if you have people who you think should be involved.
I know the veterinarians over there, they said that they had so many federal restrictions on different cannabinoids that they could not get involved at this early stage. So then they said they was gonna include the university, or they gonna include the equine industry as far as their research in this plant?
I think that would be probably regulated by a different set of regulations than the production, the actual use of CBDs and THC on animals. I'm assuming is not regulated by this board. So I'm not sure what the UC is
I
doing
just
in that
asked some
manner.
clarification. Thank you.
Yeah, sorry, I couldn't give you a better answer.
All right, do we have anyone else who would like to comment on the motion? All right, then let's have a vote. All in favor of Josh Chase's motion for the CDFA to establish the pilot program, say aye. Aye. Anyone opposed, say nay. Anyone abstain? No? Okay, the motion passes. All right, now we are on, I think we're on number 9. Discussion on changes to state and federal laws and identification of future board actions. And this will be by Joshua Kress.
So I don't have a presentation prepared. I think this is for later. Yeah, no, that's for the next agenda item. If we can just go back to the agenda, I think we're good. So I don't have a presentation prepared. We did review SB 1409 for anything that was would require additional board action, and so I've got a brief summary, but if there are any board members, anyone from the public that has any comments on SB 1409 and actions that might be necessary from the board or CDFA, we'll open it up afterwards. So the, I should have brought the slides with me too. Oh, Michelle's got it. Michelle is on top of things. Okay. So, so most of the changes do not require actions by CDFA. There's one that changes the registration timeframe from 2 years to 1 year. We've already amended the proposed fee regulation based off of the board's initial recommended fee structure. And so that's already been amended for posting. Let's see if there's nothing else on that one. The bill requires, the bill adjusts the sampling, the requirements regarding sampling procedures, and so, and regarding lab testing, the approved laboratory and the approved test methods. So we will need to go back and review the sampling procedures that were brought up today just to make sure that they are compliant with this new pending California law. And then I believe that, you know, after today, it seems like for the most part, we have a consensus on the approved laboratory and testing method, although there was still some discussion on that. But those things will need to be set by the department, and so we need to work with the board on those items and continue to work with the board on those items. We were just discussing the pilot program, and as I believe George Bianchini is about to bring up, is the Established Agricultural Research Institution notification. So there is a new requirement for established agricultural research institutions to notify the county agricultural commissioners of where they're going to be growing prior to cultivation. That will take effect January 1st as well. And that was really all even though there's a lot of various changes to language, most of them don't require any additional action by CDFA. So for instance, current law doesn't address clonal propagation. The SB 1409 includes clonal propagation into the law, things of that nature. So that was pretty much it from what we saw. Again, I think most of the things that were in the bill we were already discussing, especially regarding sampling procedures and testing methods. And again, the fees that we're already addressing. What's remaining is the pilot program that we just discussed, and it sounds like we're gonna have a comment. I believe that's what 81011 is, the Established Agricultural Research Institution notification, so. Okay, all right. So I'll leave that open. So I don't know if there's any comments or questions from the board first before we open it to the public. I know we've already got one commenter ready to go.
Yeah, anyone on the board wish to question or comment? Joshua?
Are we going to, we're going to do the seed thing after this?
Yeah.
Okay, all right.
Yeah, we were going to hold that off until the end. And then we do have federal law on here. The Farm Bill, 2018 Farm Bill has been proposed. There, as I think has already been discussed here, there were hemp provisions included in the Senate version of the 2018 Farm Bill. We haven't seen anything come of that yet, so we're obviously keeping a close eye on it. But no changes to federal law at this point since our most recent meeting.
All right, any other comments from members of the board?
Yeah, I have a quick one. The notification of Established Agricultural Research Institute to notify the county ag commissioner, is that retroactive too? So anyone currently growing will have to notify on Jan 1? Me neither. Okay. Okay.
Yeah, David's microphone wasn't on. He said he didn't see any retroactivity noted in the law itself, so he believes it's just going forward.
All right, anyone else on the board? Any other questions or comments? Okay, looks like we have a gentleman ready to make some comments and questions. Please go ahead.
My question related to 81011 relates to the original 5 versions that first came out, starting, I believe, in June of last year. The 81011 at that time created a pathway for local cities and counties to flat out ban industrial hemp. And they actually did it in 2 different paragraphs within the 1409. The version the governor got was changed about a week before he got it. That changed 81011 to what you just described, which was simply a notification of GPS. And so my question to the board is, and some of this may fall down as on a legal question, but has there been any feedback about why that was taken out? As you probably all know, Karen Ross and Mr. Perot won't comment on it because they're in litigation. That's me. And because we're contesting the fact that San Joaquin and there's another county down south, Riverside, have banned the propagation of industrial hemp outside of their legal requirements. In other words, public initiative cannot be overturned by at the county level. Is there any other feedback about whether this has been decided now, or whether counties can just randomly ban it? Now, in Prop 64, they were allowed to do that for marijuana, but they were not allowed to do that. There is no statutory language that allows them to do that for hemp. Yet we are finding some of the counties are starting to do that. Has there been any other feedback? Or do I need to keep suing the state?
I haven't heard anything on it.
Okay. I'm asking because there's many other farmers behind us that are waiting to grow, and they're concerned that they have permission to grow now, and then all of a sudden, somebody that doesn't agree with the language of Prop 64 does local political means, and then goes in to destroy a crop, which is exactly what happened to us. That creates a problem and makes everybody nervous. They don't want to jump into it and put all their money invested into it until there's an absolute clean path. And so that's what we're trying to determine, is whether we have a clean path or whether we can put the plants in the ground and then 6 weeks later they come out and ban it and come in with the D6 tractors. So that's what some of the problems have been. It almost happened to Lieutenant Governor Maldonado. He just happened to have the right phone numbers to call.
Right.
Thank you.
All right, thank you for bringing that up. All right, anyone else in the audience like to talk about the new changes in the law, the state law, SB 1409? Okay, all right. Why don't we move to item number 10, and that's proposal of amendments to list of approved seed cultivars. So this kind of goes along with what we were talking about in the morning. Joshua Kress, Joshua Chase, and Matt McLean.
Josh, you want to just read through it, or you want to read it?
Matt will read it.
Okay. Well, you want me to kind of set up what
Yeah,
we're doing
go
here?
ahead, preface.
So, we already had a motion on the board on the procedures for amending the methodology at the beginning of the meeting. So at the end of the meeting, now we are, at previous meetings, there was a proposal from Matt and Josh to amend the list of approved seed cultivars. And so following those procedures that were discussed at the beginning of the meeting and approved by the board, Matt and Josh would like to propose an amendment or an update to the list of approved seed cultivars as is laid out here, which Matt will go ahead and read through. And then would like, at CDFA, we would like if there was a discussion or comments to their proposal, and then if anyone would like to see any changes, and then if not, then following the procedures, we would like to move forward with setting up a meeting at least 30 days after this one with this updated list for public comments, that we would, again, follow our procedures again to implement this update. Did you have something else, Michelle?
For those of you who are looking at the screen, please disregard the highlighting. That should have been taken off. Thank you.
Okay, in Title III, California Code of Regulations, Division 4, Chapter 8, Article 2, adopt, Section 4920, list of approved seed cultivars. Section A, the Secretary is provided in Section 81002 of the Food and Ag Code adopts the following list of approved seed cultivars. 1, industrial hemp seed or propagative materials certified as breeder, foundation, registered, or certified seed or stock by one of the following agencies. A, member organizations of the Association of Official Seed Certifying Agencies. B, Organization of Economic Cooperation and Development. Or C, an officially approved and recognized seed certifying agency listed in Title III, California Code of Regulations, Section 3875, as provided in Section 52401 of the Food and Agricultural Code. 2, industrial hemp seed or propagative materials produced in a quality assurance program approved by one of the following agencies. A, member organizations of the Association of Official Seed Certifying Agencies. B, Organization of Economic Cooperation and Development. Or C, an officially approved and recognized seed certifying agency listed in Title III, California Code of Regulations, Section 3875, is provided in Section 52401 of the Food and Agricultural Code. 3, industrial hemp seed or propagative materials produced by a licensed participant in a state industrial hemp agricultural pilot program pursuant to Section 7606 of the Federal Agricultural Act of 2014, 7 U.S.C. Section 5940. A, the crop from which the seed or propagated materials were harvested from shall have been tested by the licensing authority in the state of origin and found to have no more than 0.3% tetrahydrocannabinol, THC, on a dry weight basis. B, the Commissioner shall be notified of the importation of all propagated materials other than seed into the county. The shipment is subject to inspection by the Commissioner and shall not be used for cultivation unless released by the Commissioner.
Jenny, can we zoom in as Matt's going through this, just so that everybody can read it? I know it's a little small on the screens there. We full screen it too. All right. If you want to keep reading, Matt, we'll try to make it so it's a little easier to read.
Sure. 4, industrial hemp seeds are tissue culture plants imported from outside the United States that meet federal importation requirements. Subsection A, the crop from which the seeds or tissue culture plants were harvested from shall have been tested by the Department of Agriculture in the country of origin and found to have no more than 0.3% THC on a dry weight basis. B, the Commissioner shall be notified of the importation of all propagated materials other than seed into the county. The shipment is subject to inspection by the Commissioner and shall not be used for cultivation until released by the Commissioner. C, for the purposes of this section, the term tissue culture means in vitro material introduced into culture from nodal cuttings at a particular time and from a single plant and grown in aseptic conditions to be used as a source of propagated material. 5, industrial hemp seed or propagated materials produced in California in accordance with the provisions of Division 24 of the Food and Agricultural Code and this chapter. Subsection A, the crop from which the seed or propagated materials were harvested from shall have been tested by a department-approved laboratory and found to have no more than 0.3% THC on a dry weight basis. B, upon request from the Commissioner, a registrant shall provide documentation confirming that any seeds or propagated materials are on the list of approved seed cultivars.
Matt,
So that was a lot of words. Do we want to go back and really quickly just review what each subsection was? Because you have 5 different categories that you guys are proposing as far as the sources for approved seed cultivars. So would you like me to just really quickly run through them just to make sure that we're all on the same page? So the first one is basically certified seed. So seed that's certified as breeder, foundation, registered, or certified seed. Those are different levels of certification. That's certified seed that comes from a member organization of AOSCA, which would be the recognized seed certifying agencies at various states and countries. The OECD, which would be seeds that's certified generally outside of the United States, although some of that may also be member organizations of AOSCA as well. And then subsection C here is the California Crop Improvement Association, CCIA, is the recognized seed certifying agency for the state of California. Again, every state has its own seed certifying agency. All of them are members of AOSCA. That happens to be ours. So the option number 1 or section number 1 or grouping number 1 is certified seed. Grouping number 2 is seed or certified seed or propagated materials, excuse me. Number 2 would be seed or propagated materials that come from a quality assurance program. It was discussed at one of the previous meetings that for especially heirloom seeds that cannot be certified to variety, the AOSCA is developing quality assurance programs for certain crops. They have not developed one for hemp yet, but they have developed one, for instance, I believe for rice, and I think there was another crop as well where they have quality assurance programs to ensure that to the consumer that the crop is of the variety and quality that is expected. However, it can't be certified actually to variety because the variety is not certifiable because it's heirloom or what have you. Option number 3, seed or propagated materials that come from another state's agricultural pilot program, and then within that, you guys have proposed that the material shall have been tested by the licensing authority or registration authority in the state of origin and found to have no more than 0.3% THC, and that the commissioner be notified of the importation of any propagated materials other than seed into the county, and that the shipment would be subject to inspection and release by the commissioner. Option number 4, hemp seeds or tissue culture plants imported from outside the United States in accordance with federal law. Again, they would have had to have come from a crop that was tested by the Oregon Department of Agriculture to have no more than 0.3% THC. The commissioner, again, would be notified of the importation of those materials, and the shipment itself would be subject to inspection and release. And then a definition of tissue culture for the purposes of that section. And then option number 5 would be any hemp seed or propagated materials produced in California in accordance with California laws and regulations, and that the crop from which the seed or propagated materials were harvested from, again, would have to have been tested by a department-approved laboratory and found to have no more than 0.3% THC. And for all of these, it would include a provision to allow for the commissioner to require the registrant to provide documentation confirming that the seed came from a source that was on the list. So for instance, if the registrant claimed that this material was certified seed comes with certification tags, and the registrant would be able to provide those. And again, just to be clear, so the list of approved seed cultivars is for registered growers that are registering for commercial cultivation. Established agricultural research institutions and seed breeders may use varieties that are not listed here under California law. Okay. Well, they had a lot of options.
I'm just, you're recommending all of this, Matt? Every part of
Yeah.
it, or it's not an and or sort of?
No,
thing?
it's all of the above. This is, I think we presented these initial findings, 2 meetings ago, Josh?
Yeah,
Maybe
2
3?
meetings, 2 meetings ago.
So, yeah, that was August 22nd, and then we had internal dialogue with the department, and I think Josh and Michelle ran it up the ladder for any legal clarification, and to my knowledge, everything's kind of been approved at the department level.
Yeah. Yeah, I mean, the department didn't really make any changes to their proposal, but we did try to clean up the language and make sure that everything was clear. It is a mouthful, there's a lot there, but obviously we want to be clear as to what the requirements are and making sure everybody's on the same page. Sometimes you have to put a lot of references to other code sections and things.
All right, if you don't mind, can I summarize it a little bit even more, make it a little bit more clear? It looks like number A is basically a certified seed, or seed that's already been regularly certified according to all the agencies. Number 2 would be the heirloom variety of seeds.
Yeah, quality assurance, a seed that can't be certified, there's a quality assurance
Right.
program.
But I think in number 1 too, initially it was, certified seed stock, and this is kind of anything that's already just within the program, right? So it doesn't have to have gone through all levels of breeder, foundation, registered, and certified.
It would be able to come from any of those levels, but
Right.
it is certified seeds. Number
Right.
1 is certified seed. Number 2 is from an official quality assurance program run by a certification agency. And then non-certified seed or a seed that doesn't come from a quality assurance program would be on numbers 3 through 5.
All right, and number 3, it looks like you're saying people who are breeding hemp seeds in other states. Am I reading that correctly? Who participated in another state program?
Yes.
Yes.
All right, so it doesn't necessarily, those don't necessarily have to be certified then.
No.
It's just what they're doing. But then if they're doing it, if we're going to bring in those, then we have to notify the commissioner. You mean the county agricultural commissioner?
Yes, if it's
Okay.
propagated material, not seed.
Okay, so it's only
Have to
propagated
be,
material.
yeah, clones.
Okay, and then also you had, number 4 was seed that would be imported from outside the United States.
Or
and-
tissue cultures.
Or
yeah.
tissue culture, but that would, you're saying that that's not necessarily certified by the organizations from number 1?
Correct. Certified is all covered under number 1. That would include anything that's been certified from anywhere. Those are a very broad group of organizations that covers pretty much every seed certification agency that I'm aware of in the world would be a member of one of those 2 groups that are listed there. And then the C is just in California, our member agency, who is a member of both of the other 2. So they are a member of AOSCA and OECD.
And then number 5 looks like it's breeders within California. So it seems like more broad than just certified seed, am I correct?
Yes,
Overall,
5
yeah,
is
there's
kind
more
of the-
leeway. But I mean, other than 1 and, I'm sorry, 1 and 2, it looks like 3, 4, and 5 or more, they don't necessarily have to be totally certified, but a little more leeway bringing them in, bringing them in, am I correct?
Yeah, 1 is within any of these certified programs with those levels. 2 is QA. 3 is pilot programs in other states. 4 is seed or tissue culture from other areas that tested below 0.3. And 5 is California, legally produced California materials.
Okay, and Josh, you were saying it was okay with the CDFA, all of this?
Yeah, I mean, we didn't really make any changes to the items that they're proposing, but we did make sure that we cleaned up the language so that way we're being clear on what's being proposed.
Okay. And then it says the shipment shall be subject to inspection by the commissioner. Is this some sort of normal thing that they normally do, or is this something special for the hemp seeds?
That language was included just to be an iteration of what is normally the procedures at the border protection stations.
Right. Okay, actually, this is pretty good. It was a little complicated, but yeah, it looks good in my opinion. Anyone else on the board have a question or comment about this? No? All right. Anyone in the audience have a question or a comment about this? Okay. All right, then. Here we go, sorry. I'm too quick.
I'm John Heaton. I'm the branch chief for pest exclusion here at CDFA. And a little bit of background, for about 15 years, I was a serial breeder at UC Davis. And then was the seed control official here in California for about 10 years. and now I'm working in pest exclusion. I wasn't clear, is 3, 4, and 5 for commercial importation, you know, seed that would be imported then perhaps for commercial production? So and then the controls on the quality of that are what?
Testing for THC content primarily?
Uh-huh.
Yeah, so it does not require certification.
Doesn't require, okay. So
That's the
just for the
proposal.
background for the board, there is one crop in California that is required to be certified before planting, and that is cotton. And it is something that the industry put on themselves to maintain the quality of their crops. So they are required to be certified. And it is, you know, it is a risky business, as we've heard today, that there's a lot of risk when you farm. There's also a lot of risk when you do seed production. And that's why we do have the seed law. And it's also one of the reasons why we have seed certification. So, you know, we want to make sure that as a new industry, that people don't get burned, as we've heard several examples today. So I think whatever the board can do to recommend high-quality seed be used for commercial production, I think it's really important to do.
Yeah, that's very good. I think on number 1 and 2, since it's already, I guess, totally certified by these agencies, you're probably safe. But if somebody were to do 3, 4, or 5, then they may run that risk of, you know, testing
For
it hot.
personal,
They're-
I mean, if someone
yeah.
was bringing a seed in and using it on their own, that's one thing. But if they're going to distribute it, I think that creates another challenge for the industry.
Right.
Yeah. And to John's point, just last year, the rice industry also put into place a requirement for certified seed. I think it's just for certain areas, but have a requirement now for certified seed, again, because of issues with quality in the Delta. And so, yeah, that is a requirement, and that's out there.
Yeah, not to cast aspersions on an industry or anything, but after regulating the industry and cooperating with seed control officials in other states, there are individuals that, you know, will have leftover inventory, for example. The germination is low, and they will try to pass it off. So that's part of the reason for the seed labeling requirements. But seed certification is another level of quality standard that tells the buyer, the farmer, okay, this seed was produced under these conditions. You have a lot more certainty that what you're buying is what's stated on the bag. We've had variety complaints. I had a number of complaints about variety not true to type when I was the seed control official. And, you know, that if you have a contract to deliver a certain quality and you don't meet that, it can be very expensive for you. And in some cases, we were able to mitigate that. But in this situation, it would be very difficult to mitigate, you know, to find an alternative market for if the quality wasn't there, like less than 0.3%.
I want to add a comment back to, originally I had requested that for options 3 and 4 that we limit the quantities, just, I guess, partially for that case where you did get bad products into the state. There was a kind of an R&D period where you'd see if there's any pathogens or off types and stuff like that. But as it's written here, it's kind of an unlimited importation into the state. So it's going to be pretty risky for options 3, 4, and 5, and we probably should have some sort of program to promote options 1 and 2.
There are companies that, farms that produce their own seed and use them on farm that, you know, they don't sell to anybody else. So, I mean, if 3, 4, and 5, I think someone wants to take that risk, that's something on them, you know, but I think if they're going to be selling, you know, you want to have the highest standards for your farmers.
Yeah.
All right,
So
thank you.
just really quickly to speak to Josh's comments. So, you know, the law as it will be amended on January 1st includes category 1. but only includes category 1. And so what the board is proposing here is basically add categories 2, 3, 4, and 5 to the available seed for a grower for commercial purposes. And again, so a seed breeder or an established agricultural research institution is not held to the list, whatever, either in current law or what is being proposed here today. Thanks,
So,
John.
yeah, I don't, sure, okay, thanks.
Yeah.
Kevin Nowell, I'm a certified organic mixed vegetable farmer in El Dorado County. Kind of to piggyback on what he said and to touch on a few things, I know, Josh, you just mentioned how 1 and 2 might be better options. I remember in the springtime, somebody from the public was up here speaking, and he mentioned how he actually filled out the DEA 357 and imported seed to Nevada, and how his seed, it came from China. And most of these other countries do not have the 0.3 THC limit that we have on hemp, because in most other countries it's fiber oil seed, so they're not testing any of their crops. And so when he harvested that crop, it tested at 3%, and he had to mitigate or destroy that crop. So all these seeds on the lists from 1 and 2 are actually they're all international seed. And because they're not limited to that 0.3 THC rule that we have here federally, I actually think 3, 4, and 5 are probably better options, because any seed that's grown in the U.S. is actually, those breeders are breeding for that, with that limit. And so I know Colorado and Oregon have some pretty reputable companies producing seed that's less than 0.3, but I mean, it's just food for thought in regards to option 1 and 2, as much as certified seed, from a vegetable grower's standpoint, or, any other crop sounds like a great thing. In this scenario, it's actually, we have no data on that, most of those seed varieties, because they're just simply not testing for THC. And the only other thing I wanted to clarify, and I think Joshua touched on it, but the seed, say in 3 and 4, the seed itself has to be tested by the Department of Ag to have less than the batch of seed has to have less than 0.3 THC. I don't see that as being an issue, besides the fact that I don't think states are doing that. So if we were to import seed from Oregon or Colorado or one of these states, as of right now, those breeders are just, allowed to ship their seed to other state federally compliant state ag programs. So that's something we would have to go to Colorado and say, hey, we need you to test these batches of seeds, because as of right now, I don't believe they're doing that.
Right, so yeah, it says the crop from which the seeds or propagated materials were harvested from.
Okay.
So if they're not doing 100% testing on seed production fields, then you're correct.
Gotcha.
That would
So
be an
the
issue.
crop it's harvested from.
Yep.
Gotcha. All right.
I got a comment too. Yeah, I guess I didn't mean to insinuate that they were the most safest options right now. They're probably all very risky options, and but I hope in the future that as California breeders and we adapt to the climate and figure out which varieties work, that the certified stuff will be better.
Of course. Yeah, I mean, it's food for thought for the public as well. Just, we could spend all the time and energy to fill out DEA 357, bring something in from Poland or China or anywhere really, and we just don't have that information.
Right.
Might be better off with everybody right now that's breeding specific to the 0.3.
Yeah, on the current approved cultivar list, the CCIA has gone through, I think Alex actually tested most of those to make sure that they were below 0.3%, because the OECD goes up to 1%, and then the UN is the ratio of CBD to THC.
Yes, I mean, I could be incorrect, but I believe from what Alex reported previously, the AOSCA standard does require below 0.3%, I believe. And so that's not just DUS that actually does include some international organizations, although obviously not all. But yeah, OECD did not include that, and so he did do some research and go through and look at, because the testing for THC content is included, they just don't have a maximum limit. And so he did do some research into what varieties were listed at testing below the 0.3%, which ones weren't. So that information is available from CCIA.
Okay, cool.
Yeah. Thank you.
All right, any other comments from the public? All right, no, any other questions or comments from the board? All right, then, I'd like to make a motion that we accept, the recommendations from Matt and Josh. Sorry. Oh, okay.
Actually, for the proposal, it would have to be posted for public review for 30 days, and then we would come back and have the public commenting period.
So the board can propose that that be done by motion. In the procedures that we approved earlier, it doesn't require a motion. It can be done either by the chair or by any 4 members of the board requesting that. So, but if the board would like to have a motion to enter this procedure and begin this procedure to post this for public comment, I think that'd be fine. And not
All right.
necessarily, it's not a bad idea. It's still within the spirit of it, so.
Yeah, right. All right, so
So,
once again, I'll make a
motion.
motion that we accept the recommendations from Josh and Matt. Anyone want to second it? Richard? Okay, all in favor, or any comments on the motion before we take a vote? Okay, all in favor on the board, say aye. Aye.
Aye.
Anyone opposed, say nay. And anyone abstain? No, okay, the motion passes. All right.
Sure. So Michelle asked if I can just really quickly go through. So in accordance with the procedures that we discussed at the very beginning of the meeting, so now what we'll do is, it falls in line with, I believe, the next agenda item, which is when we schedule the next meeting and what agenda items go on it. So when we schedule that meeting, we'll do it at least 30 days out. So that way we can post this list with the meeting notice, so that way the public has time to review it ahead of the next meeting. So we'll do that, and then at the next meeting, we'll have, again, as we had this morning, additional comment from the public, review from the board, and then a motion to either approve, amend it, or reject this update.
Very good. All right, so I guess we're up to number 11, which is just public comments. So this is general. We're opening up the mic. Any public comments on what we've talked about today? We've had a lot of people talk already. Maybe we're talked out. Yeah. All right, no. Any want to talk about any public comments or matters that were not on the agenda at all today? All right, nope. All right. Oh, we do.
Very bright. So with those new amendments for the seed cultivars, we no longer have to go by that list that you guys have published, where everything comes from out of other places in the United States. Is that true? So we're going to have reciprocity between the states for bringing our seeds in?
So the proposal is to amend what the list is in law with what was put up there today. And so what we'll do is we'll post that for 30 days for the public to review, and then the board will get a motion from the board at the next meeting, which will be scheduled at least 30 days from now. Once the board does that, as we discussed this morning, so there's a administrative process. This proposed regulation is not subject to further review by the Office of Administrative Law. So what would happen after board motion is that we would seek approval by the secretary, and then we would submit it for what they call a file and print. And it would be put into place relatively quickly. But the proposed list here applies to people who are registered to grow industrial hemp for commercial purposes, which there is no one registered at this point.
Right,
So,
because we
so it
can't
wouldn't apply to
register.
anyone currently.
Okay.
But it would, so through that process, we should have that in place before that registration would take effect.
Okay. Do we have any idea how long that registration is going to be, how far out?
Yes. So if you want to get on, you want to talk about it? Yeah, I'm looking at Michelle. So Michelle has an
Yeah,
update.
I do have an update for the registration regulations. So it is scheduled, the actual proposed regulation is scheduled to be published by OAL on November 9th, and there will be a public commenting period all the way from November 9th to December 24th.
Really?
Yeah, scheduled.
And then we can,
Scheduled, so we won't get too far ahead of ourselves, but yeah, and generally, generally when something's scheduled to be posted, it gets posted that day, almost no matter what. But, you know, with this group, obviously, we don't want to get too far ahead of ourselves, but yes, we are scheduled to have the registration fee regulation posted for public comment a week from Friday. And so we will send something out to our our listserv on the day before that, on November 8th. So everyone should be receiving that, and it will be up and posted for comment starting November 9th. And then we will go through the public comment period. So just so that way everyone's aware, since it came up and we can discuss it around, we'll throw this under the next meeting agenda items, I suppose, and things that we may or may not need to discuss at the next meeting. So what the process looks like for that is that CDFA would accept any written comments. If someone requests a public hearing, then we would have to schedule a public hearing, which would be held I believe just after the close of the public comment period. So it would be done just after the 24th, which would be an interesting time to hold a public hearing. Yeah, so we have a public comment period. They always start on Friday, they always end on Friday. CDFA has to respond to every single comment that's received in our final statement of reasons. If in those public comments we see the need to amend either the regulation or the supporting documents for the regulation, then that may need to go out for an additional public comment period of either 15 days or 45 days, depending on how substantial that change is. So this starts the process. It is a very formal process that's outlined in the Administrative Procedures Act. The Office of Administrative Law has very long document, but a very good summary of what that process looks like. So we'll be beginning that process, again, scheduled to begin it in a couple weeks here. And then once that's completed, we have to respond to all public comments. We put together our final statement of reasons, and then all of the comments, the regulation itself, all the support documents go to the Office of Administrative Law for their review, and they have it's 30 working days, so it works out to about 45 days as well of a review process at the Office of Administrative Law for them to accept or deny that. And then we will seek to have that take effect as soon as possible. I'm not too familiar with that process. Normally it takes effect quarterly, but obviously we'll seek to do that ahead of quarterly. But it should be beginning soon. That's the item on.
Something that we saw last year was there was genetics that were harvested at different times. So what you guys have to be aware of, if you guys are gonna say select these cultivars, or you're gonna actually give them, the ability to sell seeds, you have to understand, like, let's say, you said trying to fix, remediation is something that you guys do not do in agriculture currently, and it's not something you guys even addressed or considered. But I think it's kind of a dangerous position to put yourself in. So let's say I prepare 1,000 acres. I buy enough seed from your registered cultivar, right? And I grow with great practices, 100% organic. But let's say I don't harvest it the same amount of days that he harvested it. Let's say I let it go, till the end of October. And that same genetic that I bought from your registered guy is now hot. And now I have $100 million worth of stuff in the field, and you're telling me I can't remediate it. Am I going to sue you guys for $100 million? I bought the seed from the guy that you said was the right guy. You guys are playing with fire by not allowing remediation or even considering it. I think you're opening up your law people to a big can of worms, the people that don't even want to think about this. So, it's not... The CBD peaks out at 7 to 8 weeks of flower, right? And then the CBD stops, but the THC continues to climb on pretty much all of this hemp. So, you guys are jumping into a whole industry and you don't really have the experience or knowledge, and not offering somebody the ability to remediate an expensive crop is, you're putting yourself in legal harms, It's my opinion.
Thank you.
So just to note, Lawrence Durbin had to leave, so Richard's going to step in as vice chair, so.
I have a question, forgive me if this was brought up in the past, but it's hard to keep up with all the strains that are coming out these days. So if an individual comes across a seed that's not on the AOSCA nor the OECD list, but was tested elsewhere and proven to be under that 0.3, what does that person do? How does he get going? Is it through the CCIA or?
Is it in California, or are you talking about from a
California.
program somewhere else? So in California, it would have to be tested. So under the proposal that was presented today, it would have to be tested and found in accordance with whatever we come up with as far as sampling and testing procedures, and found to be below 0.3% THC. However, of course, you can also contact CCIA and work with them to certify that crop as well. And they would be the main contact for what that process looks like and how to go about doing that.
There's two avenues.
Yeah,
Okay.
absolutely.
Thank you.
Do we have any other speakers?
Move on to.
I have one question.
Sure. Do you want
I
to
think I've asked it at
discuss
the
it
la-
under next agenda items?
Sure,
And-
yeah.
All right.
Okay.
So we'll move on to the next agenda item, but go ahead, Josh.
Okay, and I'm sure it is on the next agenda. We need to finish this testing protocol. I'm just curious, we keep not making any motions to clean this up, and I'm wondering if this is the final component that's going to hold up the growing next season.
Possibly. So we didn't have a motion, but we had instructions to further, do we have instructions to further work on sampling and testing, or no? Was that something else? Yeah, okay. Yeah, I believe we've been instructed to, well, I guess I can look at Richard since that was in his area. So I think we have instructions to go back and put together a summary of everything that's been worked on regarding sampling and testing, and I think it'd be a good idea to come back and look at the complete picture at the next meeting. So if the board is looking for that, was that what you're suggesting, to come back and make sure that we're in good shape for that, and kind of have almost even a draft regulation, at the very least a solid concept, but a draft regulation, and begin working on that. I think that's a good idea.
I believe it was a board motion on, during the
Previous?
August
Yeah.
22nd
Yeah, I
meeting.
think so.
Yeah, I think we have a combination of like 3 board motions on that one, so.
It was asked that we draft the guidelines and then come back to the board
Right.
at that time.
We still had some outstanding stuff. So, yeah, so we'll do that, right? Even without another motion, we'll go ahead and do that for the next meeting. I think that's a good idea.
Can we consider within that, I'm looking at this note from Oregon about like estimated measurement of uncertainty and how they're taking, the decimal place to the 100th decimal place, so they're accepting anything up to 0.35. I don't know if we can look at that. It sounded like testing, there could be a 5%, degree of uncertainty there, so maybe something we should consider within the testing.
How to address rounding
Yeah.
of results. I think that's, you guys have some thoughts on that real quick?
I mean, if the error is 5%, I think we should do that. I mean, it could go either direction, it can go down or it can go up, and it could stay right at 3. It could move enough to the point where someone was technically illegal but still completely compliant with reality. So I think rounding up is very important. I think that we need to put that in there somehow.
Yeah, so we'll look into that further. We've got some internal experts on chemistry testing that we can consult on how, test results generally get rounded, especially with other regulatory programs. And we'll work on something on that, because I think that might be the best avenue to get some headway on that, is putting things together and discussing with them. That sounds good to you, Richard, since you were
Sounds
working
good.
on that. Okay, sounds good.
Move it up.
I guess one more thing, maybe we should start that proposal for all the varieties that we think are within the state programs as well as national programs, to start creating this broader approved list.
So right now, the list that we have that was proposed today is a list of categories of seed and places they can come from. We didn't specify that only certain varieties from each of those can come in. So, I mean, if the board would like to look at specific varieties and what's available, I think that's fine. And the board would like to look at specific varieties that they don't want to be imported, that's also something that would be worth looking at. I don't know if it's something that would be within the board's reach at this point. It might be maybe a future action, but if it's something that, if you would be interested in taking that on with Matt, or if there's somebody else that would be interested or able to take that on, I think it's a good idea. But I don't know, if Valerie or Van or Matt have looked into that issue further and might have any comments.
I'm good with the list as is and not getting into specific varieties or cultivars, but I think we're gonna revisit that language anyway next time, right?
Yeah,
Okay.
yeah, so it'll get posted for, and we'll come back for comment and discussion at the next meeting regardless. So that will be on the agenda for the next meeting as well.
Yeah, I think, I think it's important to scrutinize those varieties to make sure that we don't have some failures, or at least limit the failures from a farmer standpoint on a variety that he may have bought that may not have worked for his area.
Kentucky has a pretty good method of going about it. I think they have like cultivars of concern or varieties of concern that have tested hot. But then again, like we have a lot of microclimates here. I'm not sure how like latitude's gonna affect all that either.
I think this is exactly why we need to have the pilot program in place, so that we can do all of this work and get the information, because we can't just lay it out and say these things are fine for California.
Valerie, your comment earlier, the chancellor, you said if the, at least this is the way I understood it, if the 2018 Farm Bill gets approved, say, the end of November, that it's a go?
I would hope so. We were informed that we couldn't work on it, that was not in the running at this point, at that point in time. So hopefully, once it's legal federally to do this, then we should be able to move ahead.
So we'll have the testing and sampling protocol be on the agenda next time. The approved seed cultivar list.
Correct. And then CDFA was going to look into importation of plant materials and methods for doing that. And so we'll report on that.
And then the registration form, fee regulations.
Yeah, we'll have an update on it, although we won't, if we're doing a meeting in 30 days, obviously we won't be through the 45-day comment period. So, yeah, that'll be up. I don't know how much there will be for the board to actually discuss at that point.
And
Because
then
it'll
can
be in that process, and we won't be taking any comments at the board meeting regarding the regulation.
Okay.
So once the regulation is posted, it's a formal process in accordance with the Administrative Procedures Act. So we would allow that to take place through that comment period, and so any comments on that would have to go through that process.
Can we add the agricultural pilot program to
Yeah.
next meeting agenda? Okay, that's all I have.
Josh, one last thing, I've got to leave. I just keep the urgency there. I'm talking Josh, Chris, the CDFA, and Michelle. Keep pushing.
There's a lot of work that goes on. Did we want to try and set a meeting date real quick? I know Michelle has already heard from most of the board members on their availability 30 days out and beyond, which would give us time to get something posted and out there as quickly as possible.
So out of all the days that I provided to the board members, it looks like December 11th, 12th, and 19th are the best days, but we don't have enough for a quorum. We have only 5 board members that are able to make it, but I haven't heard back. Tom, do you know if you're going to be available on the 11th, 12th, or 19th? Either one? Okay, so let me mark you down. So that gives us 6. Lawrence, unfortunately, I did not get his schedule. And then Matt, I don't think,
I can do the 11th and 12th.
11th, 12th? What about the 19th?
I would prefer not to, but.
Okay. So it looks like, I will speak to Lawrence. It looks like it's going to be scheduled either December 11th or 12th at this point.
All right, so for 30 days, that gives us a little over a week to get the notice put together and put out, but obviously we'll do it as soon as possible once we confirm that date. Cool, thank you.
Okay.
Oh,
Adjournment, and looks like we're ending at 20 to 4, and I thank all of you for coming. Thank the fellow board members.
Michelle?
Thank you, everyone.